petition is on behalf of 1,301 individuals. These are individuals in the state of Jharkhand who are all Jharkhand TET qualified candidates. Now, this question, which is at the heart of this case, is simply this: is it enough for candidates who are available and who are properly eligible and qualified with the Jharkhand TET qualification, who are sufficient in number to fill up the posts, to actually be available and to be considered for filling up the posts? Or is there a necessity for the government to go further afield and get those who are not Jharkhand TET qualified, but who are qualified in TETs which are conducted either by other states or by the central CTET as it's called? The background of this case effectively is that some individuals who are not Jharkhand TET qualified individuals move the High Court in a writ petition, and they are deprived to us. A concession is made by the government. We are not parties there. Concession is no, we were not. We were not qualified. No. So we were not invited. We were not parties. The people who moved the High Court did not have the Jharkhand TET qualification. They said, please. Yes.
Advertisement prescribes some qualification.
Yes.
The qualification indicate this.
Yes.
As per that qualification,
Yes.
we have to purchase this qualification.
That's right.
We are the person who purchasing, participated in the process of selection. Online process of selection.
Yeah. Yes.
Concession was given by the government. On the basis of the same, they were permitted to participate and court passed an order.
Right.
Now, being agreed, because you are going to be affected by the same, you came before this court.
We have filed this.
You say like this.
That's
So this is
the learning experience for us. I'll improve myself.
learning experience.
For me.
That one case may close. We are seeing every day this bunch is being attached now. Then we find something is different, something is different. Let us come somewhere.
Parimal Kumar. Yes, for the exams, yes. If your lordship is asking me about court, no. I come up.
You are not there, that is mentioned in
Yes.
the state. But in the technical process means against the agreement you would have liked.
Yes, of course.
Come to the agreement.
Yes.
Come directly to the agreement.
Yeah.
Yes. So,
Okay.
You are the first case now. You are the first case.
First case.
Go on.
It's in the IF additional documents. Page 35. This is in 23. Double 467.
Yes, please.
Yes. The lordship sees this is the advertisement.
Yes. What is the requirement?
Sir, 142 yours.
Sir.
Page 142.
Page 35 or 35?
It starts at 35, I'm sorry. 35 at 142, it's very long.
142.
Yeah. Yeah. Same. Page 142. It's this minimum educational qualification starts at 138 at 142. If your lordship wishes, I can show from 138. 35. Yes, 35 at 138, clause 5. The scale of pay and minimum educational qualifications for the posts mentioned in clause 3 are as follows.
The post is intermediate trained assistant teacher.
Yes, intermediate trained assistant teacher, classes 1 to 5. And the minimum educational qualification is the last column, Manoj.
Yes.
If you just come to 142,
Yes.
at the end, and so it's a conjunctive, and pass the teacher eligibility test. That's Jharkhand, JETT, conducted for classes 1 to 5 by the government of Jharkhand under the guidelines formulated by the NCTE.
Where is this?
Your
Which page?
page 142 bottom.
142.
And just this part now.
Pass teacher eligibility
Pass the
test.
teacher eligibility test conducted for classes. It should be JTET, not JETT, for classes 1 to 5.
JTET.
JTET, teachers eligibility. It's called the TET across the country. Each state's prefix will be there. Conducted for classes 1 to 5 by the government.
TET.
JTET. Jharkhand Teachers Eligibility Test.
JTET.
Yes.
Is it right?
Yes.
JTET. Adopted by government of Jharkhand under the guidelines formulated by the National Council for the teachers.
For teacher.
So
Yes.
meaning thereby this JTET is under the guidelines formulated by National Council of
By the NCT. That's right.
Yes.
Now, if I can pause here for a minute, I just want to take a the statutory backdrop behind this. It starts with the art. The lordships can just see the act for a minute because it's a mainstay of
Where is that?
the right to education act. Right to education.
Why go there? We have to see the rules and the qualification prescribed.
I'll explain why. Because of very well. If you, I just want to show your lordship the entire backdrop of this. Starts with RT, goes to the NCT, which is nominated under the RT, the NCT's guidelines, and then these advertisements come. So I'm showing you the foundation behind the advertisement, and therefore the concession. This is a simple argument. The concession that they made before the High Court was legally impermissible. Just by reading this, that's our argument. That's the beginning and end of it. That's all. So I can show you the rest of the documents, etc., but unnecessarily I'll take time because this is the heart of our case. Just give a copy. If you have a copy.
I can give. Yeah, same thing.
Same.
You have two questions.
Section.
Section 23, brother.
Another setting. Another set.
You can take my put my
All right.
yeah.
Section 23.
Yes, 23(1). Now this is mandatory. It says qualification.
Yes.
Okay, so sorry.
Qualification for appointment.
Qualifications for appointment and terms and conditions of service of teachers. 1. Any person possessing such minimum qualifications as laid down by an academic authority authorized by the central government by notification shall be eligible for appointment as a teacher. So, the minimum qualifications will be as laid down by an academic authority which will be designated by the central government. Nobody else. No state government has any power. It's only the central government which can nominate what that authority is. Right now? Now, 2 for a minute. Where a state does not have adequate institutions offering courses or training in teacher education, so that requirement has to be fulfilled, or teachers possessing minimum qualifications as laid down under subsection 1 are not available in sufficient numbers. These are the 2 triggers. In either of those situations, the central government may, not the state, the central government may, if it deems necessary by notification, relax the minimum qualifications required for appointment as a teacher for such period not exceeding 5 years as will be specified in that notification. So the scheme is very clear from 23.
What is this proviso?
The proviso reads that the teacher who at the commencement of this act does not possess such qualification
May acquire within 5 years.
shall acquire it within 5 years.
Proviso.
Further proviso that every teacher appointed or in position on 31st March 15, this was inserted later in 17 months, shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the RTE. Now, the reason for the second proviso is that as per section 23(1), the first subsection, the authority had to be designated. That authority which was designated with a notification dated 31st March 2010. And you will find that at page 9 of the IA. Page 9, actually, I'll just hand up this note for your lordship's case. I have put it in my note as well. If your lordship just comes to page 2 of this note.
Let us see the notification.
Yes, I will. I'm just saying, I want to save your lordships the trouble of making notes because what I'm submitting is in page 2 with the page numbers. So,
Notification is page number.
The only problem is.
page 9 of the additional document.
Mr. Shankaraman, the only problem is if you want to add anything, there is no space.
On this.
You'll have to write it.
No, I agree. I'm just saying,
You should leave some space also for us to note down.
no, it's on page 2 there may be space. Just see page 2. Is there space? No.
Well, like game,
Sorry.
idea.
So we have to note down.
I'm sorry.
The dates are there, that's all. Page number and date will be.
That same IA that your lordships took up just now to see the advertisement, page 9. Page 9 of the line.
9 is in Hindi.
And the English bottom right side.
Bottom.
Page 9, bottom right side.
Side minimum qualification.
So the central government is the only authority that will decide that then. The state has no role to play. Now, just next page, page 10, Manoj. Page 10 is dated 23rd August 10. It's NCTE. This is page 10 of the same IA. At page 11, if your lordships will see, after dealing with minimum qualification classes 1 to 5, classes 6 to 8, just above serial number 2 at the bottom of the page, eligibility test, B, just Bindalan, page 11, just above 2, in B, that second qualification, pass in the teacher eligibility test to be conducted by the appropriate government. Please mark appropriate government because that is defined in the Act. In section 2 of the Act, appropriate government is defined. In accordance with the guidelines framed by NCTE for this purpose. Appropriate government, Manoj, is in section 2A of the Act. 2A of the Act. That Act, Manoj.
It's right.
Yes. Section 2, subsection A. Appropriate government means, one, in relation to a school established, owned or controlled by the central government or the administrator of the union territory having no legislature, the central government. Two is what is relevant. In relation to school other than the school referred to in clause 1, established within the territory of this capital A, state, the state government. So the appropriate government which will conduct this TET as required by the law will be Jharkhand. So reading this guideline at page 11, it's a mandatory requirement that they must pass the TET to be conducted by the state of Jharkhand, not any other TET. And this has to be in terms of the guidelines prescribed for that purpose. No. Oh, that's not good. The guidelines your lordships may note is at page 222. In my note, it's the last line of page 2. Very last line of page 2. It's page 222 of the main SNP paper book. No? Page 222, it's dated 11th February 2011. If I can just read this, just Bindalan, page 222. This is by NCT to all the secretaries, commissioners of education of the state governments and the UTs. Page 222, Malaj, annexure P1. Guidelines for conducting TET. It's sent to all the state governments. So, madam, in accordance with 23.1, with a notification dated 23rd August, NCT has been laid down minimum qualifications, etc. It has been inter alia provided that one of the essential qualifications for a person to be eligible for appointment as a teacher in any of the schools referred to in clause N of section 2 is that she should pass the TET, which will be conducted by the appropriate government in accordance with the guidelines. In this regard, please find enclosed the guidelines. The eligibility requirement, Manoj, is at page 223. Next page. Para 5. If I can just read in 5, small Roman 3. The following person shall be eligible for appearing in the TET. Small Roman 3. The eligibility condition for appearing in TET may be relaxed in respect of a state UT which has been granted relaxation under subsection 2 of 23 of the RTA.
It is not clause
I'm sorry?
clause
5 small Roman 3.
5.
5 small Roman 3. I'm so sorry. Eligibility, page 223. Last line of that page. That small Roman 3. So
For appearance in the TET test.
yes. So it says eligibility condition for appearing in TET may be relaxed in respect of a state or UT which has been granted relaxation under 23.2. So for 23.2, as I showed your lordships under the Act, that's the only place that the relaxation can be granted by the central government.
This is only for appearance in that test which makes you eligible for it.
That's correct.
So how this will relate?
It won't. I'm saying it won't. I'm saying that if they were to try and argue that a relaxation is possible, the only relaxation, even as per the guidelines, is limited
This is
to.
not a relaxation for appointment as a teacher.
I'm grateful that helps my case, because as per the parliamentary law in section 23.2, the only relaxations that is possible to the NCTE's mandate is if the state government writes to the NCTE and says, look, I don't have enough institutions or I don't have enough qualified TET candidates in my state. Neither is the situation in Jharkhand. When they write like that, NCTE has to write back saying, very well, for your Jharkhand, we will relax it, and for 5 years, we will relax that condition. Nothing of this sort has ever taken place. If nothing of this sort has ever taken place, relaxation is not possible. That's our argument. So you can't stand up in an inter se writ among yourselves and tell the court, look, we will consider, we will concede, we will allow other people with text from outside to take part. That's our argument. I hope I'm making myself clear. The relaxation is mandatorily only by central government in these two triggers.
Come to that eligibility that.
Yes.
First TET.
Yes.
Condition for 1 to 5.
Yes.
By the government of Jharkhand. The guidelines for the So, along with the qualification,
Yes.
passing of JTET is
Mandate.
essential.
Mandate.
Is essential qualification.
Essential qualification.
Once it is an essential, those take is JTET, which is required for class 1 to 5 by the government of Jharkhand. Complement that's the condition. So JTET,
Yes.
if you passed out,
Yes.
that should be as per the procedure prescribed
Yes.
for appearing to that and passing.
Correct.
And
How many of us?
that can only be
How many?
as per the relaxation. And that relaxation is by the central government.
Yes. Now, in
GTT.
so
No,
no,
I'm referring to
it's for
TET.
And the state.
the TET difficulty, but this is how it is across the country. Now, once the Jtet exam has been, you have enough candidates because more than 1 lakh of us have taken the Jtet and we have qualified the Jtet. So we're all available. This advertisement is for 26,000 posts, of which only 13,132 are available for us because of a reservation. Now, the 13,132 is what we are eligible
This
for.
qualification is required by everyone. It's not that for reserved category, this is not required.
No, it's one.
Everybody will have.
For it is required, is the basic qualification required.
Para teachers are
Who
different.
are working as para teachers, so that's it. That's what this, for this 13,000, everybody requires. Everybody requires. There's no
What is the
relaxation.
meaning of this 30,000?
That's the 50% of the posts advertised is 13,132. Of the remaining 50% is for para teachers. They are who are already working in the state government, but for all them also for
It
them
will
also,
be required for that only.
They would
Reservation of post for that category.
they would require that. But these people are already working as teachers. We are not. So for the remaining 13,000, we are candidates who are available and eligible. So there was no reason for those who are coming later, who have not sat for the exam when we sat for it, or who have not cleared it when we sat for it, saying that you have not.
So which year you had passed out?
2016.
16.
All of us 2016.
And this qualifying JTET
Yes, ma'am.
from the state of Jharkhand.
Yes.
This will be perfectly right for how many years?
It's supposed to be
Forever.
like forever. Once you qualify it, you qualify. It's like getting a BEd or any other kind of.
So you can,
Yes,
that you can appear then thereafter.
yes, you can appeal that.
So now you come to the advertisement and then exam took place and what types of this?
Can I just trouble you because there are a couple of arguments against us which I must show your lordships also. So that guidelines I was showing you from the first paper book, page 226, Manoj, I had read that. If your lordships can just see page 226. 226.
Third page 223.
223. Now, if your lordship can come to page 226.
Applicability.
Yes. This is clause 10, applicability at the bottom of 226. A says Stet conducted by central government shall apply to all schools referred to in 2A1.
This is Pan India.
Pan India. That's a CTET. Therefore, the CTET can't apply to schools, conversely, which are not covered by 2A1. Second, B. TET conducted by state government UT with legislature shall apply to 1. A school of the state government or UT with legislature and local authority referred to and so on. So that's what we are relying on. That's what it will apply to. Now, just after that, a school at 1 and 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with a legislature. In case a state government UT with legislature decides not to conduct a TET, a school at 1 and 2 in that state or UT would consider the TET conducted by the central government. So this is in a scenario where the state itself is not going to conduct the exam and says so. That is not the state's position today. The state has conducted one exam which we have taken.
The colleges are
Yes,
TET conducted by a state UT with legislature
yes,
shall apply.
yes,
School of the state government, UT with legislature and local authority. That means other states' qualification is valid. If the legislature and all that is there,
yes.
valid.
It says a school at 1 and 2, a school,
That is
yes,
sufficient. Prior to that.
right, a school of the state government,
Legislature,
yes,
state A legislature, state B legislature.
yes.
So qualification in state A is valid in state B.
No,
What is the meaning of this?
no, if you
No,
look,
one word.
look at 10B, 10B1,
B bar.
10B1.
The,
10B1. It says,
Mr. Sankar,
yes,
TET conducted by
the
the state.
state government or by a UT with the legislature
Like building.
shall apply to a school of the state government or UT with legislature and local authority referred to in subclause 1 of clause N of section 2 of the
It
RTE.
cannot be relevant here because this is only local authority defined.
Yes,
So that means any qualification from state with legislature or UT with legislature is applicable to all.
within that state, within that state. For the government schools in that state.
First one is central government. Second one is state government for the state government run schools. If you, Lordship, you see the definition of
So
school.
just a minute, let it complete, otherwise you will not understand.
2N1, which defines a school.
Well, one is only for local authority. But
No, no,
one is something different.
2N1 is definition of school. So 2N1 says, if I can read that, school means any recognized school imparting elementary education and includes 1, a school established, owned or controlled by the appropriate government or a local authority. So all this assistant teacher recruitment that's happening, which is happening by the government, is for its own schools, which are covered by 2N1. Which could be owned by the state or by a local authority, but 2N1 is what we are looking at, not private school.
What is the meaning of this clause? If it is applicable in the state, same state, then there was no need for having this clause. Right?
No,
If you read
no.
the first clause that the central government, like CTET, is applicable pan India,
Yes,
then the meaning of this means prima facie. And by a state with legislation or a UT with legislature is applicable in the state with legislature or UT with legislature.
correct.
It is equal.
So I'll just explain if I
This is
may.
what we understand.
Yes, I am. So
Who will
break up?
Fine, no problem.
The way I understand this verse is this. 10 is in 3 parts. Now the first part,
Right,
which is,
what meaning we have?
yes, no, but I'm saying,
For different
the
meaning.
way I understand this is a division of applicability based on territory. That's the way I see it. 10A is dealing with 2A1, which is a central government institution.
How
So
can you
if-
say B is not talking about central government, it is state only?
Because-
Central is one, A.
2A1 and 2N1 are two completely different things. 2A1, if you just see 2A1,
Central government is 10A only.
yes,
10A. B is not talking about central government.
no, it's not. That's why.
So what is the import of 10B only? You just tell us that.
Just 10B. 10B is that if a state or a UT with the legislature, which is the appropriate government, makes here a TET exam is conducted by that state's TET would apply to all the government schools or local authority schools of that state.
From where you are taking that state? That state for that no provision was required.
No, I'm taking this only because this is,
Provision was required for
I'm
that.
responding to your lordship's suggestion, because these are guidelines.
Right, so for that, no provision is required. That they have to issue guidelines for that purpose.
But very often in guidelines, they try to be as exhaustive as possible.
Not required at all.
So maybe it's superfluous, but this is the only, let me just respond. No, there is a reason. The only interpretation which I am giving is the one which is consistent with the act. If any other interpretation is taken, it renders section 23 obligatory. That it can't do. The lordship
That
sees
is a
section 20.
separate argument altogether.
No, no,
Suppose we take
that is why the interpretation has to be.
Yes.
Yes,
If we apply 10A,
yes,
10A is applicable to subclause 1 and clause here, subsection 2.
correct,
We have no concern.
yes,
10A goes out.
correct,
Come to 10B.
yes,
Suppose we go to 10B,
yes,
then it says conducted by a state government on the duty
yes,
with legislature shall apply.
yes,
Alright, so now what we have to look into, TET conducted by the state government
yes,
or by the UT
yes,
with legislature,
yes.
it will apply to whom? Now come. The school of the state government or
Of the, I'm sorry, but I'm saying the, if you just compare this with the above sentence, which says a state government, TET conducted by a state government shall apply to a school of the state government. So whichever state government conducts that, it is to them that it will apply. Otherwise, they don't have to do A and the separately. They would say A or any state government. They haven't used A, they haven't used any.
Alright, fine.
Yes,
So, but it is also using the what the local authority referred to in subclause 1,
yes,
clause N or so and so. 2
Yes.
and N, if we see that
yes.
2 and
One, yes. A school,
1 is
a school established.
established owned and controlled by the appropriate government or a local authority.
Yes,
Alright,
yes,
appropriate government or local authority.
yes,
So, here the state government means it indicates the schools of the state government and local authority means if we see this definition,
yes,
then or local authority.
yes,
So it falls within that. So it is in for one.
yes. Local authority is defined by laws in H.
In action,
Okay.
defined.
Yes,
Alright,
yes,
it is not at all relevant.
no, it's-
How to come to B?
yes,
A school refer to subclause B,
yes,
subclause 2, clause N.
yes,
2 is added school receiving granted aid means
Yes.
so and so as expenses of so and so
yes,
to a RTE act of the so and so.
yes. So government school or a
That is good.
yes.
So now what do you want to say now?
So what I want to say is this one, that two things emanate from guideline number 10. Two things. The first, that a central TET will apply only to the schools of the central government under 2(1)(a). Second, that as far as state governments are concerned, when they conduct a TET, it applies to all the government schools and the aided schools within that state. That's why it uses the word the state.
If you are asking is
Yes.
where from you are reading within that state.
From the words, I just TET conducted by a state government shall apply to a school of the state government. So it is of that state government.
You
Yeah.
are giving this because
Yes.
they may come with an argument. What may be their argument?
Their argument is based on the sentence after that, after the 1 and 2,
Yes.
that a school at 1 and 2 may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with legislature. So that is what their argument is based on. That because of this guideline, we are entitled therefore to permit those who are
Yes.
Yes. It's not continuous, right? Yeah.
Yes.
And the next line after that, in case the state government UT with legislature decides not to conduct a TET, a school at 1 and 2 in that state UT would consider the TET conducted by the central government. So, this is what is being relied upon by them to argue that we are entitled therefore to allow as a qualification a non-Jharkhand TET or a CTET. This is their. So now, the problem with that argument of theirs appears to be that it would require a listing of section 23, which it is our submission is impermissible. I want your lordships to also see the rules under the RTE, which provide for how relaxation can be granted. This is completely. Yes. This first sentence is what the High Court has relied on, my lord. So your lordship may mark that. That a school at 1 and 2 may also
You are
consider,
not disputing this situation, this can, NCT can issue a guideline,
we are not disputing,
not disputing.
not disputing.
This guideline they have issued,
Yes,
while issuing this guideline, they have given one relaxation there. They
yes,
have given this relaxation
yes,
on which they are relying upon,
yes,
and this is a relaxation. A school at 1 and 2
yes,
may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with legislature.
yes,
In case a state government UT with legislature decides not to conduct TET, a school at 1 and 2 in the state or UT would consider TET conducted by central government.
second doesn't continue.
So this is for central government and first is for the other states.
Yes,
So they have from other states,
yes,
they have been permitted under this clause.
yes,
So suppose then who would permit it? A school at 1 and 2.
yes, the school is
No. So
yes.
that can be permitted.
But that requires this procedure to be followed. That's what I'm showing your lordship. If you see the RTE rules made with reference to section 23, I'll just show you your lordship. It's in the Bare Act itself. Your lordship takes a look. Rule 38. Sorry, 17. Rule 17. I'm sorry. Rule 17.
Minimum qualifications.
Rule 17 and 18, my lords. 17 says the central government shall within 1 month notify an academic authority for laying down minimum qualification. That's been done. Now at 18, relaxation of minimum qualifications. The state government of the union territory shall, within 6 months from the commencement of the act, estimate teacher requirement as per norms in the schedule for all schools referred to in 2N. 2. Where a state government or a UT does not have adequate institutions offering courses or training in teacher education, all persons possessing minimum qualifications as notified in sub-rule 2 of Rule 17 are not available in sufficient numbers in relation to the requirement of teachers estimated under sub-rule 1, the state government or the union territory shall request, their only job is requesting, within 1 year of the commencement of the act, the central government for relaxation of the prescribed minimum qualification. 3. On receipt of the request referred to in sub-rule 2.
Provision is made at the commencement of the act because initially there was no institution, nothing.
That is correct. That is correct.
Not for subsequent period.
If that is so, then section 23(2).
That we will examine that here.
No, yes, please. So if my argument would be that while this is at the commencement, it would also apply in every situation where at some point either you don't have enough TET qualified candidates, you can't leave the children without any teachers. So then you need a relaxation for your state. So then you will write to them and say, please relax, I don't have enough TET qualified candidates. Or in a situation where, for example, some institutions are shut down, maybe because of nationalism or anything else, and then you may be in such a situation. So if we were to read it that strictly to say that it's only within 1 year, then you're leaving the states without any other alternative, but to conjure up band-aid option. Yes.
There are questions.
Yes, sir.
Petitioners who were before the High Court,
Yes.
what was their relief before the High Court?
I just,
What they were asking the relief before the High Court?
their prayers are at page 292 to 292, sorry, 289 onwards. There are 4 prayers, and I'll read them. A. Why no steps were taken?
Just wait.
289 of Tehsil. 289 Potter.
Or showing for the respondent. So why the steps are not being taken to conduct
To conduct the TET since 2016 in spite of regular demands and protests, etc., etc. Then the second prayer is at 292. How they will redress the aspirations of a large number of candidates available who have acquired all other requisite qualifications other than TET. Then press C. I'm reading all of this. Proceed for directing respondent 2 to either conduct TET in the light of Jharkhand test, etc., which mandates the state authorities to conduct the TET every year, or to consider Ctet qualified candidates worthy for participating in the selection process of the teachers in the state. So there was an alternate saying either you conduct it or allow Ctet eligibility.
So these are the Ctet persons.
Yes.
Ctet persons.
They don't have a Jtet, so they have a Ctet which permits them to apply for teacher positions in all central government institutions. So they have that. They therefore are asking for Jtet equivalence as well. We don't have the Ctet option. We have only our Jharkhand option. These are the prayers. Now, when this comes up before the High Court, at page 9 is where the judgment starts.
It's random.
And then it's mentioned, yeah, this supplementary. If I can just see para 2, which is at the bottom of page 9, bottom of page 9. The matter was heard by us, and in course of hearing on 25th July, our attention was drawn to clause 10 of the guidelines conducting TET, what I just read to you, Lordship.
So meaning wherever we see,
Yes,
then this guideline applicability,
yes,
then the later part of this B,
yes,
later part of this B,
yes, later part of this speech.
in case the state government, UT with legislature decides
Not to conduct
not to
TET.
conduct a TET,
A school at 1 and 2 would consider the TET conducted by the central government. So that prayer is only about Ctet.
a school of 1 and 2, the
Yes.
state, in that state would consider the TET.
Correct. So clearly for this to apply, the state needs to take a stand that we are not going to conduct TET. Once the state says we won't conduct the TET, then obviously it's very fair for them to get the Ctet qualified candidates and ask them also to take part. State has not taken such a stand. That's not the state stand even today. On the contrary, the state has in its counter affidavit said that we will be conducting the TET. They are conducting the TET.
Anyway,
Anyway.
not come to the.
Yes, sir. Now, if you just see para 4,
Para 4.
this is the stand that they've taken. And
Supplementary counter
yes,
affidavit.
supplementary counter affidavit. Just see extracted para 8 there.
Yes.
That it is stated and submitted that state of Jharkhand is intending to implement Jtet objectives in consonance with the geographical and regional needs, requirements such as various languages, tribal languages, culture and Hindi language speaking population within the state of Jharkhand. This is their evidence stand. So therefore, that guideline 10 won't kick in because they will conduct the exam and they will keep in mind culture, language, tribals, etc., etc. Now, para 6.
Yes.
Para 6. However, in course of hearing of these writ petitions today, Learned Advocate General appearing for the state would submit that he has received oral instructions that the state is willing to relax the criteria for eligibility as far as the candidates having Ctet examination certificate, with the stipulation that in a future date they have to clear the state TET examination and those persons should be the residents of Jharkhand. This is what we are aggrieved by because we don't believe the state could possibly relax. The state did not have this authority. The only exception is if the state took a decision saying we are not going to conduct the TET. The supplementary counter makes it clear that they will. If I can continue. Since the law provides that every year there should be a TET examination, and for the last so many years there has been no examination for testing the eligibility of aspirants to be appointed as teachers, we are of the opinion that not only those candidates who have Ctet certificate and residents of Jharkhand, but also those residents of Jharkhand having other qualification and having state TET examination certificate of any of the neighboring states shall also be given a chance to
So
appear.
they have taken both clauses
Yes,
of that applicability.
correct. When it was not even a prayer. Your Lordship would notice the prayer was for Ctet in the alternative, not for Jharkhand, any other state's qualification. They have widened it. having other qualification and having state TET examination certificate of any of the neighboring states should also be given a chance to appear in the examination with certain stipulations which we propose laid out in the following paragraphs. In view of the proposal made by the learned AG and also having considered the matter to a great extent perhaps, we hereby dispose of the writ petitions and the PIN directing the state government to conduct the TET examination every year henceforth.
Provided it's not the
That's so.
eligibility.
Correct. So para 8, we further, sorry. So
Whether the High Court has considered this clause.
they only
They have
consider this.
considered in para 2. Para 2 it is considered.
The
Clause
guideline clause. It's-
Considered.
That's
That was
fine.
heard
Clause
here.
10. Clause 10, nothing
The
else.
attention was drawn by clause 1 to the guideline of PET.
Yes,
The directive is subclause B.
correct,
The school refers subclause 1 and 2.
correct.
Eligibility of the candidate who have obtained the TET certificate awarded by another state is so and so. In case of there is quoted and in
Correct, that's all quoted, that's.
view of such position, we were of the opinion the state government is genuinely creating a number of posts
Yes.
for which the state TET examination is required to be conducted.
So, what they have
It has
not,
not been held for the last almost 9 years.
yes. No, but he's.
Last examination was in 2016.
Yes.
Not taking into consideration the sort provision, therefore the advice to the council for the state
Yes.
whether they intend to allow these candidates who have TET examination. Okay,
Now, this has to be, if your lordship just see now the directions at paras 8 and 9, these are where the errors creep in. Para 8 is page 12. We further direct that those residents of the state of Jharkhand who are otherwise eligible to appear in the examination and hold a Ctet certificate or a certificate issued by neighboring states having resident of Jharkhand shall be allowed to appear in the ongoing process, which is already started, with a further stipulation that the state shall ensure that the examination, if not held within a year, is held at least within next 3 years. Now, this is itself self-contradictory. If you're holding the exam as per the guidelines, there can't be Ctet. It's only if you're not holding the exam that you can have a Ctet. And the candidates who have participated in the selection process and have been appointed have to clear that Stet examination within a period of 3 years by giving one chance. They shall pass it within 3 years and in one first available chance. So this is the first direction. The second, we further stipulate that the state government shall not conduct the examination at least for next 3 months, so that the candidates should get some time to get ready.
It may not be that.
May not be, I mean, but all this is completely unnecessary when you have 1 lakh candidates who are eligible and available.
Where is that 1 lakh candidates are there?
It's admitted in the counter of the state, Manoj.
Let us see.
Just be patient. Para. Page. Counter in the Supreme Court.
It was not there in the High Court.
There's a counter in the High Court, supplementary counter in the High Court.
Where is that?
Counter.
Just plated.
Para. Page. No, numbers, one number.
Supreme Court.
The numbers I understand are only in the Supreme Court counter affidavit.
Alert, where is that? Where you pleaded that?
That if you just see the Supreme Court counter,
No, where you have pleaded it.
we
You have to show somewhere you are pleading.
have come to the Supreme Court, no? So,
In your pleading, it has to be there, then only the counter will come in.
no,
You have to state something.
we came for the first time in the Supreme Court, so it's only from Supreme Court pleadings I can show you.
what is the question is being come to you?
Yes, no?
In Supreme Court writ petition which you have filed,
Yes, sir, yes.
you must have asserted here that how many candidates have appeared.
Page,
Therefore adequate number of the candidates were available to participate.
page,
Possessing a TET from those are having JTET.
page H, Manoj.
Page H.
H. Page H.
There is no reply given to the list of dates.
Where is the pleading?
Ground you come to page 2 or 3.
No, so on that, if your lordships looks at the certificate that we annex at the end of every SLP, the certificate is an attestation by the advocate record in these courts that the SLP synopsis, list of dates, all form one single composite. So when replies are filed, they're fine, but it's there in the grounds also. I'll show you both. I'll show you both.
Leave aside what certificates are given.
No, no, I'm-
Argue that
Yes.
we can show you hundreds of wrong, incorrect certificates.
Just see ground L in the SLP.
That I told you 213 page is there.
Yes.
Now see the counter, let us see the counter.
States counter. बोला. Page 13 Manoj, of the states counter. That's counter on behalf of respondents 1 to 5.
Page 13.
1, 3. Para 8. In the peculiar facts and
Page 13.
Page 13, yes, Manoj. Of that counter, para 8.
Yes.
In the peculiar facts and circumstances of the present case, wherein the regular Jtet could not be conducted in the past few years due to COVID pandemic and other contingencies, and on one hand, there are enough members of Jtet qualified candidates within the state, approximately 1 lakh. Whereas on the other hand, a large number of seated qualified candidates and residents of state of Jharkhand who are aspiring to participate in the process of appointment. So here also they admit there's about 1 lakh of us. And they say there are enough numbers. So that they also believe there's satisfaction as far as quantity is concerned.
So now what is your argument finally?
So my arguments,
The
the lordship can just pick up this note
Yeah.
that sums up what my arguments are after the list of dates, page 2. The first is that section 23 is mandatory. And those relaxations can only be by the central government following the procedure that's been provided.
4.2.
Yes, Manoj. 4.1 makes it clear that section 23 is mandatory. 4.2 talks about how relaxation can be only by the central government. And as your lordships have seen, that guidelines itself provides that Ctet is only for central government schools, not for anything else. The only thing in the guidelines which your lordship noticed is that they say if the state says we're not going to conduct the TET, then the question may arise of you borrowing and using Ctet qualified candidates. But that trigger, even as per the guidelines, admittedly is not there, because as we have shown you from the counter, their stand is we are conducting the exam. And again, in this counter just now, the same paragraph, they have said that we will be conducting, we couldn't conduct it because of COVID and other circumstances. So they have never taken a stand which fulfills that guideline 10 second part, which requires them to say that we will not conduct that, in which case, yes. So that even we are not saying that you can't if you're not conducting the exam. We are saying since you have said that you are conducting the exam, then you have to strictly go by Jtet.
Basically 23(2) compliance is your argument.
Yes, 23.2 along with the guideline itself. Even if
Of the guidelines following the rules.
following throughout.
Following the rules.
Yes. Now, there's one couple of additional points. If you see 4.3 and 4.4 at page 3, we've given the page references. Service importance of TET cannot be overemphasized and has been accepted by the state. 4.3, page 3. Service rules provide that TET papers include tribal and regional languages. Jharkhand, being a tribal state with 32 scheduled tribes, requires regional language as a medium of communication with students. Jharkhand also has the third lowest literacy rate in India. Further, the state itself has admitted before the High Court that Ctet does not fulfill the needs of the state to the state regional language and local needs. This is at page 302. The Lordship will find it in paragraph 12. This is what they've said. It's part of the supplementary counter that they filed in the High Court. Sorry, it's main counter, not supplementary, main counter, part of the main counter.
Alright.
Yes. And the other ground is on prejudice, Manoj, I've mentioned that. And finally, in the directions, if your lordship notice, they don't say that certificates of TET from any states, they say neighboring states. There's no rationale really behind any of this. They shouldn't have departed from what the requirements are, what the qualifications are, when they admit that 1 lakh are available.
Relaxation is good, then that clause is good, that proviso, if it is bad, it is bad.
That's, I'm grateful, that's all
I
I,
think maybe in this speaking, they may have thought of, we don't know, but
that's
I think they
left to the local.
Yes,
So there's an account, there's.
yes.
May
That
please,
is all. Yes, madam.
may please. Now, while you are on the counter filed by the state, which has been partly dealt with by the impugned order, members, would your lordship kindly see just 2 paragraphs of the counter filed by the state, which is very relevant.
To counter file in this
Counter
before
file.
Supreme Court. In High Court.
Yes, fine. Please come to page number 323 of the same paper to which Mr. Gopal had referred to. 323. The reasons, because the High Court talks about 10, it doesn't talk about what the state itself was concerned about. Please come to page 18, page 323, Manoj. That it is further stated that the central TET qualified candidate or a candidate qualifying TET by another state can only be considered for a state-run schools when particular state government has decided not to conduct its own TET. But it is most humbly stated that it is not the case that the state government had decided not to conduct the JTET, and in these circumstances, the state government is not bound to consider or a candidate qualifying TET by another state or UT as eligible qualifications. That CTET qualified candidates can be made eligible in a given contingency where the state government is not conducting TET, but when this contingency does not exist, there is no occasion to make central TET candidates eligible or to allow those candidates who have obtained TET from central government or any other state UT. But in this scenario,
So your contention is
yes,
that the first counter affidavit filed before the High Court.
this is the second counter, supplementary counter.
This supplementary counter.
Yes, this is supplementary. Subsequent to, not the first.
Then suppose the supplementary counter says this,
Yes,
that from where this concession has come.
this is oral, my lord. It is just the Advocate General says I oral concession. There is nothing in writing. Number one.
The right statement of Advocate General is.
Therefore, they have taken it. Therefore, they have taken it. Number two, my lord. The entire writ petition, my lord, entire writ petition is allegedly by, it's called as a PIL. In service law, where there is no PIL. In fact, all the petitioners are wanting to participate in this election. It's not a PIL in that sense. They are an unregistered association. We do not know how many members are there. They came before the High Court, my lord. The Honorable High Court ought to have at least seen all these provisions, which my learned friend was now striving to point out, what are the statutory sequence, what are the regulations to be applied, whether it can be relaxed at this point of time, whether the contentions of the petitioner only for the prayer that please conduct JET, which can be at a stage we are saying that in the upcoming selection, please consider me. Now, please note the point, the rules in existence on that date had only JTET. When they went to the writ court, there was no challenge to the rules in existence. They said the rules in existence when we participated in the advertisement said only JTET. There is no challenge to that. In that scenario, whether the High Court could have rewritten the rule or the advertisement, your lordships have told me not, you can't change the rules after the game has started. As simple as that. Whether the
Where are the rules for that?
yes, so my friend had pointed out 220.
234.
No, it started like that, but the relevant portion. I see.
228 at 234.
Yes. 240. Please come to 240 and also 240, also 242. Yes, for primary. 240. Yeah, I will first show 237 it starts. Thank you. But the peculiarity of the state is so much that they take so much into consideration, Lord. They belong to various tribes and therefore it's very important. The state had itself pointed out all those. 237, Lord. Para 3E, E is the middle of the page.
So you are is 228.
Which is
228.
Yes, Lord. It started at 228, Lord. Finally come to 234, which will say qualification. Correct. Yes.
234.
Yes, sir. We'll start with qualification. 234 will start with qualification.
Yes.
Please come to middle of the page. Yes, left side will be, intermediate teacher, education, what is that, all rules of mathematics, physics, etc. Coming to the 237 middle, 3E. Candidates will be eligible for appointment as assistant teacher in the same subject group in which they have passed.
Subject is all right, we have to see
Over the page,
page 248.
240, absolutely, but I.
248.
The qualification. You must read this last part. This.
Yes, but why I wanted to read this 237 was the point which we were stressing that, same subject in which they have passed the teacher eligibility test, and after passing the teacher eligibility test in the regional language, tribal language, notified for the district, will be appointment in that particular district.
No, the advertisement is district wise.
Yes.
Yes.
Is advertisement district wise?
Post, but suppose somebody has learned Santali, then they will be posted in that district.
Let us see here.
Yes. Advertisement.
Well, we'll see, go ahead, please first complete this.
No, wait, I complete at 240, at 240, state
240.
clarify that. 240B and passed in JTET, the teacher eligibility test conducted for classes 1 to 5 and 6 to 8 by the government of Jharkhand under the guidelines formulated by NCTE. Yeah. Right. 240.
Now come to that.
42 also, it says 6 to 8 JTE. Yes,
It's not 6 to 8.
yes, both are not 1 to 5 and 6 to 8 are primary and upper primary. Please come to the advertisement.
Advertisement.
Yeah, just one more, 2 lines in that advertisement itself, at 238 on top, sorry, on the rules itself, on top, just 2 lines,
238.
238. On top, first line, 238.
Yes.
It will be mandatory to have knowledge of local customs, language and environment. Yes.
They are basically, they say residents of Jharkhand.
It is only English, they don't have all these languages.
That's a different thing.
Very well. No, that's good.
They have
They got a primary child. In fact, Devan Sharma,
That's why they said residents of Jharkhand.
residence is fine, but they didn't pass, he had passed in 16, waiting for the past 8 years. And different local customs and languages and tribal. Yeah. Advertisement will be in the additional documents, not your lordships had seen it. There also at one, yeah, it is starting at 35, but relevant portion 51.
51.
51.
Additional.
The same volume which your lordships were seeing earlier also.
51.
At 51 will show district wise resort post for non-para.
Non-para, you are non-para.
Non-para, we are all non-para.
Even para is district.
Yes, everybody is district wise only, but this is specially for non-para. Then come to 142.
So as per you, it is district wise now.
This my lord.
And then during,
After this,
after qualifying the test, then at that time they may look into about
which
this.
district, which post.
Accordingly, they
Yes,
may do it.
yes, my lord, rank wise. 142, your lordship will find the same advertisement in pursuance of these rules, which contain JTET, your lordship saw it, page 142, your lordship had seen. in
JTET.
JTET. Right to government of Jharkhand is the advertisement also.
But in that test,
This one, in this advertisement, they.
So the question is different. In JTET, when he is appearing, the person is appearing in JTET.
Yes.
So when he appears in the JTET, then what is the curriculum? That are they taking the test of language wise?
Particular language, they choose a language, particular tribal areas and they know language. That's why they get an extra advantage.
oh, he will be eligible for appointment in another district.
He will not be, he will be chosen when he comes in the merit list according to his.
Preference in the form and been prescribed?
No, the advertisement will show that,
Any
yes,
preference?
appointment.
Rules mention every person for this P, anyone other time as per secondary examination. Then we not see his gender social science and that's it, mathematics.
Test selection. We are asking for the syllabus for JTET.
Yes, ma'am. This is assistant teacher.
Yes.
Yes.
The question which was put to
Yeah.
was that for the purpose of the JTET, then to appear for the JTET,
Yes.
is it district wise, language wise, regional language wise?
We are instructed to say this language wise. We don't have the ready reference of the rules here. Yeah, you
It's the
have
state's counter.
state counter. Sorry.
State's counter in the Supreme Court at page 21 are the rules and the list of languages are at page 21 at 31
Yeah.
of the counter of the state.
Yeah.
Page 21, Manoj, is where it starts. Sorry.
Yes, please.
This is the notification.
Yes,
JTET test.
yes. These are the TET rules, Manoj, for Jharkhand.
Yes.
His Lordship just comes to page 31.
31.
This is the district wise, this is a schedule, district wise list of tribal languages, which is listed.
No,
That is there, where is
that
the
is fine.
syllabus?
What we are asking, Mr. Gopal Shankar Narayan and
Yes.
Shanaji, what we are asking is, mention the rule. That's how this appointment would be in that. You are specifying this. So where it is prescribed, number one,
Yes.
for JTET curriculum, the person has to appear this is, and those persons as per have a preference under the rules in so and option is required for their appointment in this regard.
So page 28 of this thing, just if you go a little way back, 28. So they give the pattern of the eligibility test at 28. After the table ends, just see G, sorry, not G, I.
Regional and tribal language mentioned.
Mentioned under language 2 and rules will be as per schedule 1 of the rules. For appointment to the post of teacher, the candidate will have to take the examination in any one of the regional tribal languages allowed for the district applied. So in the schedule they give for each district what those languages are. And then,
No, district applied, that means he will be eligible only for that district.
Yes.
as per this, yes,
So please clarify this situation.
Yeah.
That I'm going to complete today.
very well,
We are seeing.
yes,
To clarify any relevant rules of that, you will find it rules.
right,
This is a rule for appointment, rule says this month,
right,
so and. So far as curriculum,
yes,
for that JTET is concerned. Alright, so what prescribes so? Please clear, make it clear.
we'll do that, we'll do that.
So we're not going to complete today, we have understand now.
But the certificate mentions the language that he has studied specifically. The TET certificate issued to the candidates mention only what he has chosen and only he will be considered for that. We will take that.
We are in this case, we are considering the root part.
Yes,
But for the root part, we want some support of
He will-
factual background.
we'll give it.
We know this.
we'll,
Not
Yes,
so
sir.
much.
understood.
Yes, yes, all that happened because of the shortest order, nothing was considered there.
Yes, all right.
In fact, your lordship will see.
But you go on by your argument, ma'am.
Yes, thank you. But this, we are not 1,301 people in 2016 in the JTET, and we have been waiting since 2016 now. Your lordship will see that I showed that the rules in existence named under 309 has considered this.
You passed out JTET in 2016. After passing out of JTET in 2016, this notification of the teachers' recruitment is of 2023.
Never came.
During this period, any other recruitment was issued?
We have been waiting.
There was no recruitment.
We have conducted protests and dharnas for selection.
Yes, 7 years to it.
There's so many,
For recruitment, what?
no recruitment there. We
In
have
our
been waiting
largest
for
state council.
2016 onward. That is when we got.
Which is why they also didn't conduct another Jtet.
No, we
Because
can't.
of unemployment, the school colleges are being closed.
This is certain, don't add the anything, which is not a part of the, either doctor affidavit or the.
Could be
No, no, no,
It's a reasonable thing because
no.
you
No,
have,
no, don't add your,
there are lots of people
No,
here
Mr.
that exams and sitting.
no, no.
Next,
They have not closed the normal graduation, post graduation or any other school colleges because employment is not there.
next is
Current
the advertisement. The advertisement specifies there is a deadline to the advertisement. The deadline for applying and also acquiring qualification also.
Has to be there on that.
Protect the advertisement.
No,
Therefore,
for the purpose of,
applying for
you
this.
must have purchased this degree on or before so and so date.
My lord.
Please show that.
Yes, please come 142
142.
is the qualification, but at 149. 149.
149.
Yes, my lord. Minimum educational qualifications.
Yes, please. It will be mandatory for the candidate who have purchased the desired minimum qualification.
60.
Last page is the application of the commission.
Yes, that will be at 169 also. The reference date is the last date. Please come to the last date at 169, my lord.
Always the last date for filing application.
Yes, paragraph at 169.
Para
Paragraph 15, 15.
169.
169, my lord. For registration and entering information from 8/8/23 to midnight 7/9/23 to pay the examination fees so and so.
Albert, tell us the.
No, you know,
This
what
one-
I'm trying to point out is that all the qualifications are to have been attained on that day. The honorable High Court by entertaining,
Always there in all cases.
but the High Court by entertaining the petition, there was no stay or in that.
Anaji, don't argue. Please come to 149,
Yes.
last 3 lines.
Yes, my lord. Yes,
If
my lord.
any candidate does not possess the prescribed educational qualification by this date,
Exactly.
so you say read this much, why you are arguing here?
Last page, no.
I'm obliged. Not will.
Consider ineligible for the application form.
Yes, this is a.
Read this now.
Yes.
That is required,
Yes, my lord.
going here and there.
This
This
is
is where last cutoff date is there.
yes, yes, the cutoff date is there and this
So
is
the
the.
cutoff date shall be ineligible. Now we are asking one thing.
Yeah.
This is in the advertisement.
Yes.
Something like this has been prescribed in the rules.
About this last date.
Ma'am, please, there are two different things. If rule prescribes something like the UPSC rules, on that date you must possess this much. You cannot deviate from that.
I just get it verified, but you know, what happens is each advertisement is special and the dates mentioned therein will be only relevant to that particular selection. So the dates cut off.
Like that,
Yes.
but we are saying, the rule must say that the persons must possess a qualification.
Yes.
Okay, on the last date of name of the form. That would be fine.
Yes.
We can understand the UPSC rules prescribe so. And then they cannot change any qualification of any type.
Just check 2, 3.
Is it something in the rules?
I'll just let me check. I'll just come back to you on that.
Check it, madam. What is your next argument?
Yes. Now, again, Lord, I was submitting on this point that, Lord, the rules have been changed midway. None of this, I was just trying to submit.
So your argument was, I brief you. Rules were like this. Under these rules, this is prescribed. They were not possessing a prescribed in the rules. So once they are challenging the advertisement, asking some benefit by filing a petition through an association, in that situation, they must have challenged the rules and asked the qualification in terms of provisions of this act,
Yes.
and accordingly the court may have allowed.
Yes.
So in the present case, nothing like that is followed. So that is your argument.
Yes, ma'am.
Anything else we are rightly understand?
Yes, ma'am. Of course, Lord, and the advertisement also. So therefore, Lord, in the other limb of the argument, as a Jtet passed candidate from 2016 waiting eagerly for this selection, I had a legitimate expectation that I will be considered as per the existing rules. Of course, in service now, your Lordship will point out, and I am aware that nobody has a vested right to be appointed or considered. But Lord, I have a right to be considered. I have a right to be considered as per the existing rules and the advertisement, Lord. That right I have.
Here it is a case, the right to participate.
Yes, and to participate, Lord.
Participate in the test.
Yes, participate.
Right to participate in the test.
As
Not
per
more
the
than that.
existing rules.
Not considered. Considered would come after you qualify that, then it will come.
That's what I am seeking, Lord. Therefore, there is a legitimate expectation that I will be considered as per the existing rules and advertisement is my submission. So therefore, the rules, there is, next, Lord, the rules now, the state after the judgment of the Honorable High Court have now tried to amend the rule. Lord. After the advertisement, after everything, they have now amended the rules in 23 to say that CTET can be considered as one of the eligibility conditions. That I am bringing you to your Lordship's notice because we have filed an additional affidavit pointing out that this couldn't have been done at this juncture because of the judgment. So therefore, again, the rules of the game is being sought to be changed after the process had begun, which is impermissible in law.
The same argument would apply to you also.
Yes.
No.
No.
What argument you want to say for them?
Yes. That the rules are.
Rules they have to challenge. So now the amendment you have to challenge.
We have
Parliament applies.
for this honorable court note. We have filed an additional application challenging that here because the matter is pending before your lordship.
So now we can't do anything here.
This is anyway.
Can't do anything on the basis of an application, we can't examine.
My argument, this cannot apply to me in the present selection, to them in the present
You
selection.
can ask this much.
Yes,
You can ask this much.
yes. Yeah, that's what we are pointing out. That's what we are pointing out, Lord. So they cannot take that as an argument to consider CTET saying that I have now today amended the rules. That is what I am trying to say. Yes, Lord. And Lord, every state has been given power to.
Let us understand one aspect of it.
Yes.
Advertisement was issued. They didn't purchase the qualification.
Yes.
Relaxation was not allowed to them.
Yes.
How they have filled up their forms?
High Court order. After the High Court.
This was before.
So after we
Yes,
want
after the cutoff.
the, madam, we want the date is the chronology of the dates.
Yes.
Advertisement issue.
Yes. These are fixed
Yes.
given.
Please, we are not interested in hurrying file deciding the cases because we know. So advertisement was issued.
Yes.
When was what was the last date of filling of the form was?
The writ petition was filed on 18th.
Oh, last date.
Last date, September.
Last date of filling of the form was
September.
September 23.
Yes, my lord. 7th September.
7. When the writ petition was filed?
Was filed. I don't know the date, any incorrect date will be modification is there. Last date, yes. Sorry. 18th May 23.
18th.
Writ was filed.
What is the date of advertisement? August. It can't be filed in May. And that means it was filed before that.
Okay, advertisement is July 23. We don't know the exact date because it doesn't mention the date.
Mentioned August only in this.
So the writ doesn't challenge the advertisement.
Nothing is charged.
Writ is your saw 3 prior. They just want to be considered. They might have known whether the advertisement is coming or not.
It is prior to the advertisement.
And they didn't amend it thereafter. It is prior to advertisement. They didn't amend it.
But as on the date of the advertisement, the rules are still applied.
So what is the date of the advertisement?
Yes, Lord.
Date of
The
advertisement
date,
was
if it is July 23 is what it says, Lord. The date is not there, Lord, actually.
July. We have over there.
It doesn't say actually.
Advertisement doesn't give any month, Manoj. It's either July or August, and my dates I've put August. Miss Mona is saying July. State will give you the date.
State can give.
State can give you the date.
Advertisement always has the date on that.
But unfortunately, it doesn't mention.
Then they should start giving. I'm being instructed to say Jharkhand mein nahi dete. I don't think that can be.
Very peculiar.
you can say. At present we can't say.
Bearing on this side.
So they'll be having a date.
They must have a date of it.
Date must be there or when it was published in the newspaper.
19 July.
19 July.
Because when it is published in the newspaper, they see it.
And when you receive this notice of writ petition?
State received.
Counter was filed in less than a month. Counter was filed, your lordships asked when was the notice received?
Counter is filed on 18 June,
25,
25 June,
25/6 counter filed.
25 June, one counter,
Those 2 days.
14th August, supplementary counter.
Between those 2 days, between May 23 and
May
June 25 with the counter.
is the repetition date.
18th May and 20.
So, our thought process is
Counter says.
to issue them advertisement after filing your counter affidavit. And after serving the notice,
Yes,
notice was served to you
yes,
already,
yes,
and thereafter you issued this advertisement.
yes.
Any, we will ask the questions whenever you will ask. You are from the state, Mr.
Yes, Mr. I will done
In the first matter, I am accepting your lordship for
For
that.
state.
Yes.
And you are for
for the state, the second matter.
second matter. Alright. Okay, double engine. You are candidates,
And
triple engine. Alright.
no, out of the two petitions.
Yes, ma'am, now this argument is over.
Yes, yes.
Now what is next argument?
Just one more point. Just like in the beginning also I mentioned, this was not a PIL, number one. This was a personal litigation only, can be mentioned or treated as a PIL, not because they were interested candidates who wanted to participate. They were,
For the petitioners,
sorry, not they, yes,
for the petitioner, association or something.
association and one individual, my lord. Today, interestingly, the individual who filed the writ also filed a counter here, has already got an employment in the KV based on his CTET and he is joined there. The candidate who has filed a counter here and who was a petitioner there,
CTET, Uttara Abhiyat,
who have an edge, my lord, because, sorry, my lord.
petitioner number name I am.
Yes.
Jharkhandi, CTET, Uttara Abhiyat.
Yes, yes. It's an unregistered association and we do not know how many people are there, what is their qualification when they acquired it. I'm
They are not getting any employment of that.
I'm just saying that, not that.
Like, another aspect which we are asking you,
Yes,
then suppose, then in this case, some interim orders were passed by the High Court.
no, that's what I was coming to, Lord. There was no interim order.
So then how they have applied?
Only based after the writ petition, Lord.
Allowing. What is the date of that improved judgment?
Impugned judgment is 20/12/23.
Last date was expired.
Yes, in September 7th, on September.
Other writ also.
No,
Yes, just see page
They
one.
were not over one.
No, there were other writ petitions also before the High Court. It's not one only.
That will also say, take
One
for
says
my
that.
petitioner.
Yes, so what was in that?
Same judgment. They were not there.
Judgment is same, but there were other writ petitions also. Number of parties. In one, there were 308 petitioners.
Prayer, same for everybody.
That's right, but what was the prayer, they were local candidates, CTET or JTT.
They are all CTET is what they say.
But
But
what was
they
the
can't say, they can't understand this like this.
prayer?
Because this is by association.
Yes,
CTET, whatever it is. Now, anyway, let us understand
yes,
that the judgment was passed on 2023.
yes. There was no extension of time or anything by the High Court.
4 days, right?
Where number of the writ petitions filed, number of the persons were there.
Name there, that's my point.
There.
Yes.
But what is the relief in that?
Can't see.
You please clarify this by tomorrow.
Yes, 1 second, Lord.
We have to ask another thing.
One thing.
Whether in any of the case, please note down,
Yes.
in any of the case, any order might pass that they be permitted to fill up their forms.
In between, no minutes.
They were not permitted by the SOQ.
Extension of date. That was permitted.
Just after this judgment,
Yes,
prior to that, last date was September
yes,
23.
yes.
Then after this judgment, any corrigendum was issued to fill up,
On 10th of January 24,
which is not mentioned in this list of dates.
I got it in my.
In this.
It's-
No, it's not.
Sorry, I got it.
This must be complete, Mr. Gopal.
Subsequent events are not put, I should.
You have to put everything, here.
And I can give
Nothing
my.
subsequent, it is all before the date of hearing.
No, that's correct. I'll revise it and give it to you tomorrow.
Not, it's here. I can give the dates.
So you have to.
20th December is the judgment.
So then January, judgment was issued.
It's there on record, my lord, in the additional documents at page 267. Additional documents, page 267. There is a notification dated 10th of January 2020. 267. All the cases are mentioned there. That's it's got it, not 267.
267 of SLP.
No, the additional documents which you were seeing, the advertisement, etc.
Extending the date.
Yes, my lord. In compliance of the judgment of so and so passed by the Honorable Jharkhand High Court in a petition so and so by the CTET passed candidates association, Surat Bihar so and so. In these cases, the local residents of Jharkhand state who have passed CTET or TET from the neighboring state and who are willing to appear in the Jharkhand primary school trained assistant teacher joint competitive examination 23 online applications for the above examinations are invited. For inviting applications from the above mentioned type of persons is being activated soon on the website of the commission. Also, in the light of the above order, rescheduling of the examination schedule of Jharkhand Elementary School trained assistant teacher joint competitive examination 23 to be held from.
What are the last date extended? There is no date finally given.
This is all. You don't know further in notification, it's not on record.
Any comments from Mr. Gopal Shankar?
Was it further extended? Because we were here not.
This is also the practice that no last date is given.
We have
The exam was carried out in.
What is only the exam schedule?
Exam-
Cut off date now.
exam was held on a series of dates through.
We have only asked that what is the last date after extension to submit application? Is there that in all?
Kindly see 269, 270. 269, 270. Please see, Madam. Kindly see over the page, at 270. That is only for the disabled candidates. That's all. Attached prescribed form to the commission. Application submitted after the period will not be considered by the commission. And the concerned candidate.
Disabled?
Yes, that's all. So therefore, we assume that it has to be before this date for everybody.
During the date of last date of submission,
This is
not
what.
there.
No, no.
It is only invited. Everyone invited.
Yes, no.
Open.
Open.
Date is announced by.
Come with a certificate and the examination center, all right.
By finding it from 70 of additional documents.
270?
270 is from disabled candidates.
I just pointed
There are
out.
269.
Disabled category candidates submitted valid online
Yes,
application.
I just pointed out that. Then we note that things get amended.
Nothing.
Even this doesn't last, then there comes the rule next, 29th of January 24.
Application attached prescribed home commission from application submitted after second.
Yes.
Considered by the commission concerned, candidate will have to be sent.
Yes.
For the convenience, so it is not for both examination, no? This is only various centers located in these.
Will be able to get it.
Okay.
Because page 267 is only showing that the date of test is now
Fixed
pre-posted.
now, yes. And
It's
others,
not for extension of time for submission.
no, it doesn't say so in that language, not all it says is you also apply now. Your lordship can see online applications are invited, it says. For inviting, we are opening the website, is what it says.
Please give this all clarity with.
Right.
the dates.
We have a, we also have, yes.
They do it in here. Then what is your next argument?
Yes, yes. Your lordship will see just the last point and show it and close it. Now, the rules have been amended, that portion of your lordship, like,
Here is that
it's filed along with the counter.
counter by the central Indian.
State.
Page number 60.
29th January.
Yes, my lord.
They have amended.
Yes. In exercise of powers so and so, governor of so and so, amendment. The rules 22. Amendment rules 23 as amended, following amendments are made in the rules of 23 constituted for appointment, promotion.
But this is prior to the last date of the candidates.
No,
Have to declare one.
No, my lord.
This rules amendment,
This is
29 January. In that case, 30th January. And so we have to understand this, let us know.
the rules shall be.
Cut off.
Kindly see, my lord, kindly come to C. Commencement, short name, extent and commencement.
Page number
The rules are called, that the same page 60 itself.
60, yes.
These rules are called as, shall be called as Jharkhand Primary School Sahayak Correction so and so, my lord. 24, its extension so and so. These rules shall be effective from the date of issuance of notification.
That's all right. The cutoff date now for submission of application is after this.
10 to.
So whether this will be applicable or not.
In our submission, it will not be.
Your submission maybe, but it must be supported by law now. Because this is prior to that cutoff date.
Cut-off date extension itself is questionable only because of the judgment, because we are challenging the judgment itself, whether it is applicable or not for them. Secondly, we know that they cannot change the rules once the process itself has started. So therefore, whether they could withstand that is another question.
Now, where is that provision regarding this in this amended rules?
Yes, 60,
There we have to see,
63,
page 63,
rule 6,
assistant teacher appointment and so qualified teacher,
Rule six.
TET conducted under the so and so.
in addition, qualified teachers JTET, then not in addition to the above, such residents of the state of Jharkhand who have qualified CTET conducted for class 1 to 5 under the guiding principles formulated by the NCT or qualified in the TET by the neighboring states of Jharkhand are included. That also it doesn't say. In the appointment procedure on the post of assistant teacher, subject to this condition that it shall be mandatory for them to qualify TET, JTET in the chance available within and before 3 years after the appointment.
As well as the initial condition initially they have to follow.
In the judgment. And para 7 also.
Not judgment, the rules also provided that. So that is
That's condition, yes. Yes. Rule 7 is for the next 6 to 8.
This advertisement is only for 1 to 5 or 6 to 8 also?
Both, not primary and upper primary, both.
So you are only concerned with primary,
Both, not. Both.
primary and upper primary. So your petition is of primary.
Both are not mixed in fact.
Yes, so you are also.
Both have.
We have to go.
It's elementary education which has defined as class 1 to class 8. So it's split into 1 to 5 and 6 to 8 for the purpose of the qualification. But otherwise it's both, it's qualified.
Now, what is next now?
Stressed by some, pointing out some judgments about how it is relevant and important, why states have the power to fix their own JTET, why they are conducting it themselves. In fact, the recent one was Devesh Sharma judgment, in which they consider the importance of the elementary education and the primary education. How the teachers, in fact, the judge, the court said B.Ed also is not relevant today. It's only TET. Diploma and DLED is relevant.
After tomorrow,
Very good.
and to take this,
Maybe the dates also, sorry. about it.
you divide it and give it revised.
Yes, ma'am.
And give the compilation of the judgments also.
Very good.
Tomorrow, give it, return it back. Okay. This, batch of written. How many cases are listed today?
Not only three.
Six. 80. Back it up.
Two of Jharkhand, one of them.
Here you tomorrow.
Slightly different. I would detect, Bihar's case may be detached. Slightly different.
Both are brother, sister.
They have challenged our rule.
Yeah.
They have challenged the rule, man.
Consider that. Why we should, why?
No, it's different. Anyway, no, it's different.
Consider.
Yes, they are not allowed that.
But we not have it, yes, ma'am. We have not had it.
Look okay. The concept of the petitions are. What further arguments? List tomorrow. Registry is requested, right? this case tomorrow. If necessary. Kindly obtain order from Honorable the Chief Justice.
You have been granted, but
Commission, my lord, item 35, my lord, not present, but it was called, my lord.
So there no can be.
No, Lord, if we convenient to have it on the Monday, Friday, my lord, or on Wednesday.
It will take time, Mr. Mehta, I've seen that case also.
I see,
I've seen that matter also.
very well.
Like there are so many documents filed by the respondents. They say this is a bundle of the documents filed, like this. So we have to look into it. And it's a case,
Or Wednesday or Thursday, any Wednesday, Thursday, my lord.
so we will take it in the next Tuesday, what we can do.
No, it's a miscellaneous came, my lord. Monday is a holiday.
14,
That,
we will take that 24.
I was only requesting
24 we will take on 24.
24th, I have difficulty, my lord.
Then we take on first,
Wednesday is not possible, my lord, any Wednesday.
Wednesday not, Wednesday will not be listed, we know. Therefore, this case, because we have heard for a long time, so we requested to take order from Honorable the Chief Justice.
I see, all right, my lord.
Yes,
Very well.
so we take on 24,
No, 1st October, you must.
first October. All right, first October.
1st October.
Very good.
I don't know 26 months in the position.
So what is the urgency in that?
We are not independent.
Not getting, who is for the other side?
The,
Who is for the other side?
Mr. Nanda.
Huh?
Mr. Nanda plays together, Bobby.
So we take now this matter, then on in October, we give a fixed date. We give you a fixed date on that.
Let's, may I mention item number 16?
Item number
16 years.
46 को कोई डेट दे दीजिए अक्टूबर में 22nd of October.
Lordships, no.
Take in November better. 10 November. 10 November.
Lord,
12.
Lordships,
So may I mention, I
Lordships, Siddharth Gupta.
that wages matter, my learned friend is here, which will also.
Yes, please. What happened in that?
Added discussion, the figures are slightly distant, but we can charge.
Lordship, I have enough.
They are-
They are also here.
I'm also trying to persuade my client.
You have to mention.
to come to a settlement.
Madam, we have seen that completely, that case we have seen. You have to decide the back pages. How much you are asking?
But our figure is around 1 crore, they have come to 62 lakhs. Now, the point is this, we said if you are giving us